Hi, good afternoon, everyone. This is Rajiv Khanna from the law offices of Rajiv Khanna PC, immigration.com. This is our bi weekly, every other Thursday, community conference call. I'll first answer the questions that have been posted. I don't think we'll have time for new questions. Well, we will do the frequently asked questions first, then the regular questions, and if time permits, maybe new questions. I doubt we'll have time. The first frequently asked question is the fastest method of getting spouse of a green card into the USA and how to reduce the waiting time. Now, this question does come up quite a bit. You got to be careful here. For instance, the plan that Arjun is making is that I will get married. I've got my re-entry permit so I can go outside if I want to. Once I get married, I will have her apply for a tourist visa. Well, there really is no guarantee. In fact, it's highly unlikely that the consulate will easily grant the tourist visa. I hope I'm wrong and I hope we are pleasantly surprised. But normally, if your husband is living in the United States, consulate is not very easy going about giving visas because they suspect that once you enter USA, your husband will apply for your green card. So first problem is getting a tourist visa itself is definitely questionable. Second is, remember when you apply for a tourist visa, any representations you make must be absolutely and meticulously truthful. You can't make things up. For instance, if you intend to apply for a family-based case, your wife shouldn't be saying that she's not going to go for the family-based case, etc. So you've got to be meticulously truthful. Let me just double check, make sure everybody can hear me. Okay, one second.
The conference is now in conversation mode.
Can you folks hear me okay? Can everybody hear me? Hello?
Yes, Rajiv.
Okay, just
Rajiv.
just want to make sure. Okay.
The
So
conference is now in presentation mode.
just want to make sure I'm not talking to myself. Okay, so going back to so therefore tourist visa is by no means guaranteed, but certainly certain visas that are immune from this problem of not having any ties in India, etc. Those there are visas like that, H1, L1, O1. Some of these visas don't really care whether you have family living in USA. So you could, if she qualifies, you could look at something like that. So therefore, the first flaw in your plan is that you are assuming tourist visa would be guaranteed or even easy. I don't think so. You can certainly relocate to India if that is within the parameters of why you received your re-entry permit, your permission to stay away from USA. But if it is not within those parameters, for example, if you gave a reason that I want to wind down my business in India, but you're actually going to go live with your wife and that's the real reason, don't do that. That's a bad idea because that is fraud, that is misrepresentation, and that can create more problems than solve. Okay, stay away from that. Star 5 if you have a follow-up question on this, folks. Star 5. Press star 5 on your phone if you have a follow-up question on this topic. Okay, no questions. Let me go to the next frequently. Oh, there is one. Okay, one second. So Texas, go ahead please, Texas.
Rajiv, this is Rajiv. So
Just,
you mentioned about being meticulously truthful while applying for a tourist visa. So you said if it's meticulously truthful, the tourist visa be applied, but it's not guaranteed, right? If
correct.
Myself and my wife is meticulously truthful and say the real reasons, and we can still apply for a tourist visa. It may not be granted, right?
Right.
That's your point.
Right. So if she tells the truth, her chances are slim, but not impossible. I've had other cases where they were approved, and a whole lot of cases such type of tourist visas were not approved.
Okay, okay. I think you answered this question already before because I made a statement before that I would not apply for a family-based visa.
Okay,
I would not even apply.
okay.
Without applying, only I'll apply for tourist visa, but I thought based on the logic and law school, since my wife has not applied for a family-based visiting card and he has no true intention to come to the US, and tourist visa can be granted, that's what I made.
Yeah, but how does that help you if you don't apply for her green card? She's still going to be outside the queue until you apply for her visa, her green card. She doesn't start the queue or the running period of 2 years or whatever the waiting time is. So not applying for her green card doesn't help you.
Got it, got it. So my thought process is once he comes here, maybe live in the US with tourist visa for 6 months, extend 6 months, next year for 2 years, then I had plans to go back to India with my wife, and while I work from India, and from India I apply a green card for my wife, not in the US.
But then you would have wasted so much time. The time that she was in USA, that would be wasted, right?
I get it, totally agree, I get it. But the point here is, even if I waste time, when I apply for a green card from India, I'll be living together with my wife. Whether it from that time it takes 2, 3, 4 years, that I have to wait. But other thing is, I'll be living together with my wife, right? So,
Well, I feel that you'll be better served by applying for a green card as quickly as you can.
okay, yeah, that was my first plan, that going to India, get a job there, because I don't want to live. I want to live with my wife from day one. That's period, right? So I don't want to make any chances. So my original plan was to go to India, get married, get a job in India, apply for a green card from India, whether it takes 2, 3 years, then come back to US. But now I'm finding it difficult to get a job in my field. So that's the reason I was going with the backup plan. Maybe be here and work here, and then go to India to my wife after 6 days
Well,
for tourist visa.
Arjun, I think you understand the variables quite well, and of course it's a personal decision. But if I were in your position, I would be applying for a green card as quickly as possible. Okay?
Okay. 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 Thank you.
You're welcome. Good luck to you, sir. Bye-bye.
Okay. Okay. Okay.
Okay, so the next frequently asked question, this comes up very, very frequently. Is new H1B visa stamping needed if you change employers? So let's say I've got my H1 good for another 2 years, the visa stamping good for another 2 years, and I went from employer X to employer Y. Can I still travel with employer Y's approval notice and employer X's visa stamp? And the answer is, in my opinion, yes. Consulates have been saying to people, no, we want you to come in for a new visa stamping, but their own standard operating procedures suggest that a new visa should not be needed. Now, this situation will change if you are coming in for the first time. So if you are coming in for the first time, you've never been here, and let's say you got stamped for employer X, but then you decided without coming in to change to employer Y, and employer Y got an H1 approved for you, can you then travel using the other employer's H1, the X employers? And I'm doubtful. I'd rather not have you do that. Okay? So the question here from Kranti was, I have a question on H1B stamping, working with employer A. Visa is good till November 2018. Shows the name of my previous employer. I want to visit. Should I go for new visa stamping? I don't think you need to. I don't think you need to. Once again, I caution you that if you ask the consulate, they might give you a different answer. But in the Foreign Affairs Manual, in their standard operating procedures, I remember seeing there was no such requirement. So you could travel on the old visa and the new approval. Star 5 if you have a follow-up question, folks. Star 5. press *5 if you have a follow-up question. Okay. Next set of questions from BJX 369. This is about H1 visa stamping in Canada or Mexico and the importance of I-94. I'm currently working on H1B. Visa is with the previous employer, valid till September 2017. And I've got an approval through a new employer. Can I get my visa stamped in Canada? Well, first of all, like I answered before, oh, your visa is only good till September, next month. Okay. You can, yes, you can get your visa stamped in any country, which is called TCN, Third Country National Processing. It's a good idea to check with them beforehand. Sometimes if they have too much of a workload, especially in Mexico, they might temporarily stop taking TCNs. But people go to Jamaica, Canada, Mexico, all these countries. Am I eligible for Dropbox option? I don't know, sir. I don't know, or ma'am. I don't know because I don't know what the rules for the Dropbox are. I keep forgetting them. But whatever the rules are, if you read them, they're not difficult to read. And if you qualify under them, then obviously the answer is yes. Now this is an important part. I can also see my I-94 expiring in September 2017. Look, this is important. And I've had people get into some very difficult situations because of a bunch of reasons. Once you're inside the United States, your status is governed by the I-94. You could have a visa good till 2020, but if your I-94 is expiring tomorrow, then you're going to be out of status day after tomorrow and illegally present, unlawfully present. So I-94 is important. If your I-94 is expiring, you've got to get that extended, whether it is through an H1 extension or if you already have an approval and you can go outside with a visa for a visa stamping. So whatever it is, remember, for H1 visa to be granted, H1 approval from USCIS is required. H1 and L1 require a prior approval from USCIS. H4 and L2 do not. So make sure you extend your I-94 whichever way your lawyers advise, whether through applying for an H1 extension or if you already have stamping to go outside USA and come back because your approval was for a longer duration. And for whatever reason, the I-94 given to you was of a shorter duration. That can happen. Sometimes if your visa is good till September 2017 and your H1 approval is good till 2019, you went outside when you came back because your visa was expiring in 2017, CBP, which they shouldn't do it, might give you an I-94 good till only September 2017. That's wrong. But that's one example. So you can go back and get that corrected through CBP sometimes if they've done it by mistake. *5 if you have a follow-up question. *5. Press *5 if you have a follow-up question. Okay. So here is another one that comes through quite often. What are the options of an H1B, if an H1B visa is denied and petition is sent for revocation? So sometimes if you go to your home country, India, Australia, wherever you're from, and you apply for your H1 visa, if the consulate decides they're not convinced about the approvability of the visa, they will decline the visa and they will send the petition back to USCIS in USA to be revoked. What can you do? Pretty much nothing. What will happen is, in due time, in a few months, USCIS, upon receiving this request to revoke, will send a notice of intent to revoke to your employer, giving them X number of days, typically 30, as to why that visa, that petition approval should not be revoked. If USCIS is convinced that the employer is stating the correct facts, and on those facts the H1 is indeed approvable, they will what is called reaffirm. They'll reaffirm the case and send it back to the consulate for visa stamping. but there's not much you can do about it. So the backstory is, I went to USA in May 2014. Feb 2016, I moved to work for another employer, small company. The new job was remote, so I started working from home. Received RFE, went to India. While I was in India, the transfer got approved. I came back to USA with approval notice as proof. So then an extension was filed with employer B. The extension also got approved after RFE, extended till September 2019. So in Jan 2017, he went to India for his marriage. I went for visa stamping. The visa officer asked me about my role, client, and other questions. He answered them correctly, but then they sent the visa for revocation. Employer doesn't know what to do. They said they don't want to spend any more resources on this case. So they want him to continue working from India. In other words, they outsource the project. So SJ wants to know, what are my options? Is it possible to have the case reconsidered? Not until a notice of intent to revoke is sent. Okay, if this is only for stamping, how long? No. This case is going back to USCIS. Am I still subject to the quota? That depends. If the revocation is for fraud, then you are subject to the quota. If revocation is for other reasons, it's just a complicated question to make general rules about. What happens to my assets? Well, you can always get the assets back. You can try getting a tourist visa. That's one way to do it. Second is to send somebody a power of attorney. You can get together with lawyers of the state where your assets are and get a proper power of attorney made out in the name of a friend. They can take care of it for you. Can I legally work for the same employer? I guess in India the answer is yes. The tax issue I don't know. But you don't have to pay taxes both in India and USA. There is a relief available for people in your situation. But I'm not a tax expert. You need to talk with a chartered accountant in India. By the way, I want to add one more thing. They can start your green card if they want. You don't have to be in USA to get your green card started. That might also be a good idea. That's pretty much all I have to add. *5 if you have any follow-up questions. Press *5 if you have any follow-up questions. Okay. So, New Mexico, go ahead, please.
Hi, Rajiv.
Hello.
I wanted to ask if,
Go ahead.
so if I choose to find a new employer, and say if they want to hire me and they want me to come to USA, so will they have to apply a new visa, or I cannot do that until there's something is sent to the employer, the reconsideration?
I think until that notice of intent to revoke comes, we won't know what the reason for the revocation is. So I think you'll be better advised to wait for the notice of intent to revoke.
Okay, can we proactively USA to get the note?
You cannot expedite these cases. They will take their time.
All right.
Okay.
Okay, thanks.
You're welcome. Good luck.
Thank you.
Okay. So I think these were all the frequently asked questions. Yeah. So let's start with the regular questions now. Once again, folks, I won't have time for new questions, I don't think. So the first one is an anonymous 0001. My friend is doing a 3-month internship on CPT F1, but there were no tax deduction in his paycheck. I think this is something, look, I'm not a tax lawyer, you have to confirm it. Even on the IRS website, this information should be there. But I think FICA, the social security taxes, can be skipped for students who are on OPT and CPT. Double check that, but I think that's possible. How to pay taxes? Please talk with a CPA. I really cannot help you much, but I do know that from the paychecks, if you don't deduct FICA and you are on student visa on CPT or OPT, that should be okay. But please have it confirmed. My knowledge of taxes is very limited. *5 if you have a follow-up question. *5. Okay, let's go on to the next question. Okay, now this one is going to be a little difficult to answer. Folks, there are a couple of things that it's difficult to answer. When you have a lawyer representing you, I don't want to second guess them because they know more facts than I do about your case, number one. Number two, it is never possible for me to help you fill out forms, because if I help you fill out forms, look at the bottom of every form, it says whoever helped you fill the form must sign the form. So I won't help you fill the forms, but I can answer generic questions. How much time are prevailing wages taking? Last time, whatever we discussed, it's in the last week's recording, last session's recording. Take a look at it. The times are about the same everywhere. Company starts parallel advertisement. How many months advertisement will be valid? All recruitment is valid for 6 months from the date it was started. Okay. So if you start ads today, from today to 6 months, those ads are valid. HR said they can't start form preparation parallel, but they can, you see, these are difficult things for me to get into. How I handle it, how your HR or your lawyers handle it, I can't get into it. But I can definitely confirm that if your lawyers are telling that the advertisement is good for only 1 month, they are wrong. They're wrong. And I cannot tell you which level any job will fall under. But typically, in the IT industry, if you are going for EB2, chances are you are going to get a level 4 wage. Chances are you'll get a level 4 wage. *5 if you have a follow-up question. *5. Okay. Next question, let's see. Shweta ji says, this is our 9th year in USA. Spouse is an H1B holder, recently switched jobs. I'm working on H4 EAD since Jan 2017 in a non-profit. His extension, H1B's extension, is expiring in November 2017. Both last and current employers have filed his H1B extension along with my H4 and H4 EAD. If my spouse's employers have filed my EAD with his H1B, what are the chances of getting H4 EAD approval before November 1st? That's difficult for me to predict. By the way, there's no guarantee that the H1 and H4 will be decided together. And there's also no guarantee that H4 and H4 EAD will be granted together. So I have 2 pending EAD renewal petitions, one from last employer, one from current employer. Since last employer might have withdrawn his H1B, is my first H4 EAD still a valid petition? No, I don't think so. Because if it is filed as a part of the same application and the main application is withdrawn, then no. Only the second one would be valid. I'm afraid that I may lose my job if EAD does not arrive. There's not much you can do about that. But if you're working for a non-profit, you can try doing one thing. And I'm not sure this is going to work because your husband's H1 needs to be approved before the H4 can be extended. You can try expediting. Remember, USCIS has certain expedite criteria. I think there's 6 or 7 of them. So if you Google USCIS expedite criteria, it'll pull up. Maybe you can try requesting the government to expedite the case. But it's dependent upon the H1. They may not be able to do it. You can try. *5 if you have a follow-up question. Shweta ji. *5. Okay. Mabali Malanga says, I hope you are well. Yes, sir, I am. I hope you are well as well. I recently finished my undergraduate coursework, but missed the graduation application deadline. I've got my EAD and will need to send in compliance within 10 days. What are my options? Mabali, I have to look at the regulations. One angle that I can think of, again, I haven't looked at the regulations, HCFR 214.1 or 214.2, where they talk about you are entitled to your EAD if you apply within 60 days of finishing your coursework. But what if you don't graduate after that? I'm not sure what happens. If I were you, before you start spending money on lawyers' opinions, I would go to the DSO, the designated school official, ask them what is the best way to do this. Okay? I suspect there's got to be a way, but go back to your DSO. I don't know the answer off the top of my head. *5 if you have a follow-up question. *5. Press *5 on your phone. Okay. Now we are going to Raj, Catchram 12. I'm on L1B, which is good till December. Employer is doing my H1B because I'm not subject to the quota. Can we premium a pending case? And the answer is yes. If you file a normal case now and later on H1B premium becomes available, you most certainly can convert it to premium. Is there any issues with the H1B processing like RFE? Can my employer apply for L1B if required? I don't know what L1B criteria were used, but L1Bs have become quite difficult. So, but can they apply for an extension if you have time left on your L1B? Why not? Can another employer apply for your H1B? Yes, they can. What are the general reasons for an RFE? Oh, that's a very difficult question to answer. Typically, they can question the availability of the job, employer-employee relationship, whether the job is a specialty occupation requiring a degree, etc. So it's very difficult to answer that question. It's like asking a doctor, how can people fall sick? You can write a book on that. *5 if you have a follow-up question, Raj. *5. *5. Okay. Let's go on to the next one. Anil Kolati says, my friend having an H1B with company A valid till 2019 visa stamped, due to some issues I don't want to work with company A, I want to switch to company B. Yes, transfer is possible. Because you got your visa stamping done, transfer is possible. If company A revokes his H1B, is it possible to transfer H1B? See, the way I understand the law, this has gone through some flux. The way I understand current thinking, not even law, but the current thinking of government, what I understand the government to say is this. If your H1 is revoked before October 1st, the day it was supposed to become effective, you are still subject to the quota. If you don't get a visa stamping done, you are still subject to a quota. But if you got the visa stamping done and your H1 was not revoked in that fiscal year, before the beginning of the fiscal year, you should be able to carry that H1 over to another employer and not be subject to the quota anymore. Okay? *5, and you don't have to have traveled to USA. If you have a follow-up question, press *5. Okay, let's see. And this is from New Jersey. Yes, New Jersey, go ahead, please. A lot of background noise, but I can hear you. Go ahead.
I'm sorry, I'm traveling, so I just started
Okay.
Yeah, I basically Raj, the previous question was mine regarding that H1 and H2 question. So that was my question.
Are you Raj?
Yeah, I didn't hear your
Sir,
response.
are you Raj?
That's correct, yes.
Okay. Well, this call is being recorded, so it will be posted today or tomorrow. But the bottom line is that, let's see, you can premium a pending case if you want. That's not a problem. Once premium is restored, your employer can apply for an L1B and another employer can apply for H1B. Okay?
Okay, so based on my previous L1, I mean H1, so another employer
Yes.
can apply
Yes.
for
Yes.
okay.
Yes.
So if that happens simultaneously, like my employer applies for my H1 right now, and then if I apply for another job, so can they do it simultaneously?
Yes. Yes. As long as there is no contract issue, you haven't signed any contracts, multiple employers can apply for your H1 at the same time. Okay. Yes, sir.
Okay.
All right.
And what do you recommend, sir? Like I have my L1 valid until December mid. So now that I have requested my employer to apply for the H, so they are okay with that and they'll be applying it. But should I, like if I don't get the approvals or any response within December, so should I go in for an L1 to be safe?
Yes. Yes, I think you should. But just coordinate with all your H1 lawyers and make sure there's no overlap. There's no overlap of H1 and L1. First H1 gets approved, then L1 gets approved. Now you are on L1. So make sure there's no overlap, but applying for an L1B extension is a very good idea. Okay?
Okay, got it. And what are the chances that they will revive this email processing in October? So they should do it, right? Like,
I think they should, but I don't know what they are going to do. If you look at their background history, they have opened it partially. They first allowed premium processing for physicians. Now they have allowed premium processing for non-profits and research.
non-profit.
Yeah, so I'm hoping they'll open it again. Okay.
Okay. And one last question, sir.
Yeah.
So can by any chance, like this H1 that I have right now is the previous one that I had is from my current employer itself. So can they, do they have an opportunity to revoke it by any chance? Like that H1 is expired now.
Yeah, I don't think that will hurt you because that's an old H1 that October 1st has come and gone. If it was done before the beginning of the fiscal year on the year it was approved, then you would have a problem. But that has come and gone. Did you get a change of status to H1?
Change of status to H1, correct? Yeah, that's right.
Okay, just make sure you discuss this with your lawyers. Just make sure you discuss it with your lawyers. But looks okay to me. Okay?
Okay. All right.
Good luck, sir.
Thank you.
Oh, you're welcome. Okay, so we just did Anil. Now, St. James says, I worked for employer A offshore as a manager for 4 years. Moved to USA on L1A. Worked for 3.5 years, same role. They filed for my H1B in the 4th year. I moved to employer B. I've been working with employer B for 2.5 years. I think you've interrupted your 3 years. Somebody should look at the regulations. The normal law is, if you want to do an EB1C green card, you've got to stay within the same family of corporations. You can't step out that family. Number 2, 1 year out of the last 3, when you make the application, you must have worked for a branch of this company, branch, affiliate, parent, etc. of this company outside USA. So if we count back 3 years, you haven't been outside USA, working 1 year for this company. There's an exception to this rule when you come and start working for the same group of companies. So let's say you worked 1 year in UK for this company, came to USA and worked for this company 4 years. In the 5th year you want to apply a green card, you can, because the 3-year rule doesn't apply to you since you're working for the same group of companies. But now since you stepped out, I don't think you have that exemption. But somebody should look into this. I don't want to definitively say yes or no, because for all we know, because of that exception, we could say that, well, I don't think it's gonna work. I really don't, James. You can try. You can try. *5 if you have a follow-up question. Yeah, I think you changed, because of the change, I don't think it's gonna work. You changed companies and you stepped outside the family of companies which made you eligible for L1A and EB1C. Okay, next question is also St. James. Try to make it one question, guys. I've been working on H1B as a manager. My I-140 is approved. Completed 6 years. Employer is sending me to another country for 1 year assignment. Can I re-enter USA based on current approved H1B and become eligible for EB1C? Well, once you work outside USA for 1 year as a manager or executive employee, and you want to come back on H1B rather than L1A, that's fine. You are still eligible for EB1C. You are required to wait for 1 full year, 366 days I would say, before you can apply for L1A or EB1C. *5 if you have a follow-up question. *5. Vijay rocks. I have filed my H1B along with my wife's H4 and H4 EAD. Everything got approved. H1B expires 29 September. Extension starts from 30th. My wife did not receive H4 approval notice with I-94 due to address error, but the lawyer has a courtesy copy. You are traveling to India to get a stamping done. Well, I am confused. I hope you're on the phone. Are you on the phone? Press *5 if you're on the phone. Press *5. Okay, I don't really know what's going on. So, H4. Okay, I don't really know, but let me just give you a generic rule. If she has applied for change of status from H1 to H4 or F1 to H4 and she travels out, both her H4 and her EAD application are gone. Okay, so I think you need to discuss with your lawyers exactly what the situation is. Without knowing more facts, it is very difficult for me to give you an opinion. Since you're not here, I can't really discuss this with you. Pranay Kumar says, employer is not giving me my PERM. Can I get it via a Freedom of Information Act request? I think you can. So far, people that I know have been getting copies of their PERM application. Why don't they want to share labor cert or I-140? I don't know. Beats the heck out of me. Most companies do not file I-140 immediately. They file it after 1 or 2 years. They can't do that. They have a 180-day deadline. Once the PERM is approved, I-140 has to be filed within 180 days. *5 if you have a follow-up question. *5. Okay, let's get that. Okay, New Jersey. I have 2 from New Jersey. Let me answer the first one. New Jersey, go ahead. You have a question.
Hi, Rajiv. If I move to a different company, can they immediately file my I-140? I have approved I-140 already, so can they file my I-140?
No. They have to go through the PERM process. Okay,
so they have to wait for some time?
No, they can start the PERM. They can start the PERM anytime. Even before you join them, they can start the PERM.
Okay, so I mean, if I give them my I-140 receipt number and they can just go ahead and start the process.
They don't even need your I-140 receipt number. They can start the perm without any information from you regarding the earlier case.
And in the meanwhile, my employer, current employer revoked it, then will there be an issue? Will I able to hold my priority date?
Priority date is yours the moment your I-140 is approved. Nobody can take that away. But,
Even if my current employer revokes it.
yes, even if they revoke it. Only if USCIS revokes it for fraud or error, you lose your priority date. Under the January 17th regulations, that is the new law. On top of that, here's another interesting thing. If your I-140 stayed unrevoked for 180 days, when was your I-140 approved?
1 month back.
Okay, if you stay 5 more months, 180 days, then if you move, you also have the right to keep extending your H1 with any employer on a 3-yearly basis. So, the moment your I-140 is approved, the priority date is yours even if they revoke it. If you wait 180 days and the I-140 is revoked after 180 days, not only is the priority date yours, but the right to extend H1 with any employer is also yours. The new employer has to start a green card all over again, but it will carry the priority date of the old green card. Okay?
Oh, okay. I still don't understand I'll be eligible for extending my H1B for 3 years. That I don't understand.
Right. The way it works is, in order for you to get H1 extension based upon the I-140, the I-140 should not be revoked. Okay? But the law now says if your I-140 stayed approved for 180 days and was revoked after 180 days, you get to carry your right to extend H1 even if the I-140 is revoked by the employer, and you can extend H1 with any employer. Make sense?
Makes sense. So currently this is my first H1B and I have only one.
So you have time. You don't need to worry about that because H1 extension is not your problem. Your main problem is your priority date. That's already yours. You want to leave tomorrow, you can.
So if my employer is threatening me that I revoke my I-140, doesn't matter to me.
You can tell them, sir,
Does not matter to me.
revoke it over a bottle of beer or a bottle of wine. I couldn't care less. Do what you need to do.
Alright. And and they are not providing me labor certification. So H4 EAD is fine to get it, right?
The only reason
my employer.
The only reason I would want to look at your PERM application is so that I know what your background was. Because you don't want to have one background stated in one PERM application and a different background in another. So, if 2003 to 2005 you worked for Tata, but in the new application you put down 2005 to 2006, you can't have those kind of discrepancies. But if everything was done right, then what do you care? They don't want to give it to you, what do you care? That's fine.
No, I just wanted to. I read somewhere that you need labor certification to hold priority date if your I-140 is revoked.
You heard incorrectly. You heard incorrectly.
I read somewhere.
You read incorrectly. What else?
And okay, so if I ask for a labor certification through H4 EAD, will my employer get notified?
No.
No. Okay. Okay.
All right.
I'm good.
Good luck, sir.
Thank you.
You're welcome. Okay. We have another New Jersey questioner. Go ahead, New Jersey. I think it's the same number called in twice. Okay. Let's skip that one too. RP Canada. I filed an I-824 asking for a duplicate approval notice, AOS to CP. So basically you're converting your case to consular processing. I still haven't heard anything. I was looking at the Nebraska 824 times. They were backed up to like they were doing February 2nd or was it January 2nd, 2017. So they're backed up like a good what, 6 months, 7 months? Yeah. You filed it in June, so take June months. Maybe in December you would hear. I have received nothing, not even receipt number. But you've got the checks cashed, so you are fine. Your checks will have the receipt number on there. So if you get copies of your canceled checks from the bank, you should be fine. Okay. Star 5 if you have a follow-up question. Canada. Star 5. Sir, go ahead. Canada, go ahead.
Hello, sir. What happened? Like my 485 is pending now. They send me some refer, but I'm not living in US. I'm living in Canada. Then how can I get that copy?
How can you get a copy of the I-824 receipt? Is that what you're saying?
No, 824 they don't send. They say I called the US IF. They say they're going to send to the employer, and second copy they're going to send lawyer.
Okay.
They say I'm applying for the Texas Service Center actually. This one.
Okay.
They are processing right now 1st April 2017.
That's good. That's
And
good.
my 485 is pending, but they send me RFE. But I'm living in Canada, I didn't get copy. And lawyer office also changed, company lawyer office also.
Okay.
Then how I know that?
Okay, what you should do is you should call the USCIS customer service and you tell them this is my new address. You can also give them an address of a friend in USA saying if you can't send it to Canada, please send the RFE to this address and then have it collected from there. Okay.
That's fine, I can give somebody else address while I'm
Yes.
in US.
Yeah, because if they won't send it to Canada, I think they should. But if they won't send it to Canada, you can just tell them, okay, I'll give you a local address. Please send it here. Okay.
Okay. And sir, generally they send receipt or no? 824
They do,
send
of
receipt
course.
or no?
They have to send a receipt.
And I call them, they say we cannot talk with you, lawyer or company. Either one we can talk with.
Yeah, but you should tell them I'm calling about my. When you filed the 824, you are not asking for a duplicate copy of the I-140. You are asking for, or I-140 approval. You are asking for the case to be converted to consular processing. You should tell them I'm not asking for anything to do with I-140. I'm asking my 485 to be converted to consular processing. That's my personal case. You have to talk to me. You have no choice.
Okay. And generally, how long take time to 824 approve to the National Visa Center?
I don't have those figures. Sorry.
Okay, sir.
Okay.
Thank you so much.
Oh, you're welcome. Good luck.
Thank you.
Bye. Okay. Oh, I've got New Jersey back on the phone. New Jersey, go ahead. New Jersey? Yeah.
So, hi Rajiv, I have a question regarding the earlier question on I-140. And the question is, if I-140 gets revoked, then and if the dependent EAD, dependent H4 has an EAD, so does the EAD also?
Okay, listen. I actually just answered this question half an hour ago on our website. I don't know if you had posted it there. I was very backed up. I had no time for a month and a half. I was not able to answer the questions on our website. But I just answered this question. You can actually go take a look at the recent comments. On our website, people post comments and ask questions. And this is what I answered. I'll repeat it for you. I said, this is the law. If your husband's I-140 is revoked after 180 days, you will keep your H4 EAD as well as the right to extend H4 EAD again based upon the already revoked I-140.
Alright.
Okay? Only If the the I-140 is revoked before 180 days, then government can cancel your EAD. They probably won't, but they can cancel, but you won't be able to extend it again. To extend an EAD, there has to be an I-140 either not revoked or revoked after 180 days. It doesn't matter whose I-140. One I-140 of your husband. Okay?
Okay, so they have the power to revoke it.
Only
they
if the I-140 is revoked before 180 days. Once it goes past 180 days, they won't revoke the EAD.
Right.
Okay? Anything else?
Thank you.
Oh, you're welcome. Good luck.
No. Thank you.
You're welcome. Okay, I've got New Jersey back again with another question. Guys, I gotta move on. You can't keep me on the same question and keep calling in time and time again. I'll do it this one time, but last time I'm doing it for you. Go ahead, New Jersey.
Sorry, Rajiv, to call again. It's regarding, so if that firm certification, labor certification have a different salary and the offer letter has a different salary, which salary is the employer, has to pay to the employee?
Well, that's an impossible question to answer. But I can tell you this, whatever they put in the perm is your future salary after you get your green card. Okay?
Okay.
That's it. I have nothing to add to that. That's a complete answer. Okay?
Okay.
Good luck. All right, back to it. So, guys, you gotta keep moving on, please. Okay, I've got other things to do as well. So bear with me, work with me. Don't keep me bringing back to old questions. Let's see. This one is Rajiv QU. He's got I-140 priority date of 2012, EB2 approved, currently in the 7th year of H1B. I-94 is good till August 29th, 2017, another 5 days. Employer said, okay, you gotta go. I applied for FMLA due to my wife's condition. Do I have a 60-day grace period? You see, the 60-day grace period doesn't work like that. If your I-94 is expiring before the 60 days, then you don't have 60 days. You have only till August 31st. No, what is it? Valid till August 29. You only have till August 29. But you could do a compelling circumstances EAD if that works for you. And you can also do, unfortunately, our office won't be able to do it in 5 days. It takes a lot of paperwork to file comparing circumstances. I think you can file a tourist visa change of status, and that should be okay. While that is, to wrap, and then once you file the tourist visa, then file for compelling circumstances EAD. Let's see if that works out. Okay. Star 5 if you have a follow-up question. So what I'm suggesting is file for a tourist visa, or if a lawyer can file your compelling circumstances EAD now in the next 4 or 5 days. I know we won't be able to. We are pretty heavily committed on our existing caseload. So if we have time, we'll be able to do it. So apply for a tourist visa or get a lawyer to file compelling circumstances and apply compelling circumstances once your B2 is pending or B1 is pending. At least you've got something to fall back upon. Star 5 if you have a follow-up question. Star 5. Oh, okay, here we go. Pennsylvania. Go ahead, Pennsylvania. Go ahead, please.
Sir, say like example, we have some time and then to file the compelling situation EAD. So once the EAD is filed, can we allow to stay for
Yes.
more time?
Yes. Until your case is decided, you can stay, no problem. Okay?
Okay. And meanwhile, if I get some H1 job somewhere else, still I can
Well,
come back to my status.
you can, but you probably will have to go outside for visa stamping.
Oh, even my EAD case is still,
Yes.
with
Yes.
USCIS.
Yes. Yes.
All right. Okay, Rajiv. Thank you.
You're welcome. Okay, let's go on to the next question. This one is which one did I just finished? Rajiv. Now we come to Kumar Sena. I'm on H1B, changed employer from A to B. I got H1 extension till November 2018. Spouse got only till November 2017. Her I-94 is also valid till 2017. Should we apply for H1 extension before we apply for a visa? We are leaving for India this month. No. See, there's a difference between H1 and H4. For H1, you need an approval from USCIS before you can apply for a visa. But for H4, no such prior approval is needed. You can just walk in and based upon your marriage certificate and your H1, they will give her the H4 visa stamping. Absolutely. So that was your question, and the answer, Kumar, is you do not need to apply for her H4 extension. Walk in and get her visa stamping done. Star 5 if you have a follow-up question. Star 5. Okay guys, I just want to remind people who are just logging in, I won't have time for new questions. Then we come to Anand Brahmabhat, H1B and green card for nurses from India. What is the wait time to receive a green card? You see, remember something. Nurses get to the I-140 approval stage very quickly. The I-140 gets approved. But for green card, they have to wait under EB3 or EB2 category, depending upon which category they're applying for, like everybody else. So it's still going to take 7, 8, 9 years because you were born in India. Now, if your spouse was born in a country other than India, you can take advantage of their country of birth. That's called cross-chargeability. The category will be probably EB3 or EB2, probably EB3. Can a person apply for oneself in a new H1B under nursing profession through a hospital while being on EAD through spouse? No, you cannot do an H1B for yourself as a nurse. I don't think so. No, sir. Star 5 if you have a follow-up question. Star 5. Okay. H. D'Souza says, I-94 on H1B transfer. Visited India, H1B transfer was in progress. I got the H1B approval with old I-94 good till 2020. But while coming back, I got it till 2018. Do I need to worry about the new I-94? Yes. By 2018, you've got to get an extension done, and there's only 2 ways to do that. 1, get a new visa stamping if your visa is expired and come back using that. Or 2, apply for an extension just like you normally would if your H1 were expiring. Only 2 ways to do this. But let's see, why did they give you less time? Oh, you know, in your case, you might be able to get an extension by going to CBP, Customs and Border Protection, asking them to correct your I-94. Because there's no reason, unless your passport was expiring, just because your visa was expiring, that should not have been the consideration. They should have given you an I-94 all the way to 2020, and it appears to be a CBP error. They will correct it. Okay. Star 5 if you have a follow-up question. I have a hand up for somebody from Wisconsin. Okay, then another one, 2 people from Wisconsin. Wow, what a coincidence. Okay, let's begin with what I believe is your H. D'Souza. Let's begin with H. D'Souza. 1 second. I'm sorry, I don't know what I just did.
I Rajiv here, D'Souza here. Okay.
Yes, sir, go ahead.
When I applied for my transfer, they used my old I-94 number. But I went to India after it was applied, and then I got new I-94 number when I came back from India. So the old I-94
I-94 was extended through the new approval process. So what should I be doing now?
No, hang on, Mr. D'Souza, I'm a little confused.
Okay.
You got your approval till 2020.
Correct.
Okay. Then you went to,
Transfer.
when you got your transfer done, then you went to India, and when you came back, they gave you an I-94 only till 2018, correct?
No. I went to India before getting approval. Before approval. It was just applied, not approved. It was pending.
Oh,
So pending is
so your most recent I-94 is the one till 2020, correct?
No, not in 2019, next year, until next year.
No, how can that be? Because I'm assuming that your 2020 got approved when you came back into USA, no?
Yeah, but when they filed my H1 application, they used my old I-94, not new I-94.
Okay.
So after my H1,
Mr. D'Souza, when they originally filed your H1, you got it till 2020, right?
2018, not 2020.
But you have said in your question, you said I got my H1B approval with old I-94 number extended till 2020.
Oh, maybe so sorry, I told me.
Oh, okay. If it's a typo.
Completely
Oh, okay, no problem. It's a totally different situation. You have to apply for an extension, and you can do it 6 months before expiration date. Okay.
So I need to can I go to CBPS and get that corrected?
No, it cannot be corrected because your approval was till 2018. It can't be corrected.
Okay.
Okay.
So I need to get new visa stamping.
Not new visa stamping. H1 extension through USCIS.
It is already approved. It's approved now. It is for 220, but with the old I-94. That is my question.
See, that is what I don't understand. But you keep saying old I-94. All I care about, I don't care old or new. The most recent I-94, does it have 2020 on it or 2018 on it?
No. That's the problem. Most recent I-94 does not have 2020. My most recent I-94 is 2018.
Okay.
But
Now,
I got approval all my old I-94. That is 220.
okay. Now, I think what you need to do, Mr. D'Souza, rather than me going around in circles, it's better that you go to your lawyers, show them your whole case, and ask them whether you should be applying for your H1 extension in 2018 or 2020. Ideally, I would like something in writing from your lawyers. So send them an email.
I asked.
Yeah.
I asked me when they said your latest update will be the current. That's what they said. So, but I don't trust them. That's the problem. Because
You'll have to.
information from me.
You can send an email to me. I will set up a consultation for you. I hate to waste your money on something like this if your lawyers can help you. But I have to look at your I-94s. I have to look at your filing history and talk with you briefly about 10-15 minutes just about your case. So I have to look at your paperwork. I can't really comment like this.
Okay, I'll do.
Yeah.
Okay, I'll do that. Thank you very much.
You can just send me an email to help@immigration.com. Okay.
Yeah. Okay. Thank you very much.
Good luck. Good luck. Let's go to the second person from Wisconsin. Okay, Wisconsin, go ahead, please.
Namaste Rajivji, this is Rahul Joshi. If you remember me, we have talked several times, and this other person, Hilary, is one of my friends, and I think he didn't explain the case correctly.
Okay.
So when you ask what is the most recent I-94, when you say most recent, do you look at the date or the number? Just the date.
I look at the date it was issued.
Right. So the most recent time. So basically, what happened was he traveled to. So he had I-94 with number 100, for example. He submitted that for the H1 extension process, and when the extension was pending, he went to India, came back in, and then he got another I-94 while coming back in, which was number 200.
Right.
But then his approval came in,
Right.
and the I-94, with the approval, the old I-94 number 100.
Okay.
Now it is extended
No.
until 2020. So the
Don't worry about the numbers. The numbers are irrelevant. In this situation,
Right.
let me forget about Rahul. Listen to me.
Sure.
If I have an H1 extension or transfer pending, I'm allowed to travel. When I come back, I'll be given an I-94. I don't care when that is valid, till how long it's valid. But when my approval comes, that is my most recent I-94, and if it says 2020, I'm good till 2020.
So do you have to do anything to reconcile?
You don't have to do anything, but I do want him to talk to his lawyers, make sure what the facts that you gave me, based upon those, he's good till 2020. But let's just make sure those facts are correct. Okay?
Sure, absolutely.
Yeah. I don't see any problem with the facts that you gave me.
Okay, thank you,
All right?
sir.
You're welcome. Good luck.
Nice talking to you.
And to you, sir. Bye-bye. Okay. So last two questions. Once again, guys, I'm not going to have time for new questions. Now, this one is, wow. That's a long one. Let's see. SG22, H1B approved I-140 priority date December 2010, more than 10 plus years in USA, my God. When I got my green card, it used to take less than 6 months, start to finish, to get your green card. It's crazy. I-140, I'm working on EVVC model, employer, vendor, client, working with the same employer. Need to go to India. Mom is not well. I'm sorry. I've been avoiding going to India last 3 years to avoid stamping. Yeah. My current H1B in passport with same employer is expired. I will need to go. I got current stamping done through Sydney, Australia. Expired in 2015. Currently a resident of Southern California. Would you recommend I go to Mexico for stamping or India? I don't know the answer to that question. I think it's going to be tough no matter where you go. And they do ask for end client letters. Sometimes they even call the end clients. Your wife can continue to stay in USA while you go to India for a brief trip. If you were to leave for 10 months, it probably is not okay for your derivative to stay here. But if it is for a brief trip, it's okay. Your mother's severe critical health, I'm really sorry to hear about that, but it's not going to help you in your visa stamping. Can my wife continue to work and stay in the US? See, USCIS has said, if your trip is short and casual, it's okay for the derivative to stay. But if it is a long duration, and I don't know if there is a formula for that. I'm pretty sure there isn't. So, I mean, this is just anybody's guess. How long can she stay back and work? I would hate to make a guess about what USCIS will consider to be too long or too little. But the thing is, what is the worst case scenario? They're just going to say you worked here while your husband was not here, you're out of status. Well, go get another visa stamp and come back. So I guess she can continue working. Can my current employer call me back by applying for my H1B again? They can. If there's a genuine project, they can always do that. Green card process does not get interrupted unless there is some substantial problem that affects green cards. Normally H1 denials have no impact on green card. Green card can go on in your absence. I don't know when they will start the premium processing. I won't be able to answer your questions about how to fill DS-160. Okay. So, but I can tell you this, if your I-140 has been applied for or approved, I-140 is immigration. PERM is not. Okay. So anybody who's applied for I-140 or gotten I-140 approval, their green card or their immigrant visa has been applied for. I-140 is immigrant visa. Look, use your common sense. The rest of the questions are really not that big a deal. Whatever the truth is. So generally speaking, if your family is in USA, you would say yes, because that's the truth, right? But I can't help you fill the form, sorry. *5 if you have a follow-up question. Star 5. Okay, these are the last two questions we have now. Kumar Sena, I'm on H1B, recently changed employer A to B. Oh, this is the repeat question. Okay, we already did that. Jay Vijay, my friend has a situation. Worked with employer A in H1B, got his I-140 approval with EB3 priority date. Okay, 2006. Moved to employer B, got his I-140 approved. Priority date 15 Jan 2012. Employer B is his current employer. EB3 dates, priority date is current as per first employer. Yeah, he will carry the priority date of his old employer. Okay, that is the normal, that's the way it should be. He should be able to file adjustment of status based upon the priority date from employer A. What should he provide as proof? I think your lawyer, let their lawyers worry, because government is supposed to do a scan and they're supposed to know which priority date is attributable to which individual. You can, so let's say the visa bulletin says that the dates for September are current. You can file, not in August, but in the month the dates are current. So anywhere from January 1st to September 31st, that application can be filed. Star 5 if you have a follow-up question. Star 5. Okay guys, thank you everyone for being here. We went a little bit over time. I wish I had more time. I would have dealt with other issues. Last week was good. We were able to spend a lot of time with people. But today I'm a little bit rushed. We had a lot of questions to answer. I'll see you again in 2 weeks. It's always a great pleasure and delight. Thank you everyone. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.